right, welcome everyone to this CJR workshop hosted by the Decent Criminal Justice Reform Center. You are probably all familiar with us. We are an advocacy and criminal justice research shop at the SMU Dedman School of Law. The CJR workshops are opportunities for researchers to present works in progress for discussion and contemplation by the field. I am thrilled today to welcome Professor Anastasia Bowles and her program assistant Eliza Buckner to talk about this fabulous court observation and interview project that they have had going for quite some time in Arkansas. It's just an amazing project that I've gotten the real privilege to be sort of close to as it's kind of unfolded and see different kind of presentations and pieces as they get them ready. It covers everything from just the core operations of the criminal courts to language access, and it's super exciting to think about like what we can do with court observation. So I am thrilled to have them here. For people who are not familiar, the way this plays out is they are going to present for 20-30 minutes, and then we will have time for discussion. Feel free to put questions in chat as they arise. At the end, I will ask questions, but also we tend to be a small enough group that people can unmute and ask on their own as well. And with that, oh, and I'm sorry, Professor Bowles is at the University of Arkansas, the Bowen School of Law at UA Little Rock, and runs the Center for Racial Justice and Criminal Justice Reform, which is just, again, an amazing kind of co-center. I love when we get to present from other law school centers. So welcome, and I will turn the floor over to Professor Bowles and Eliza Buckner.
Thank you. Thank you so much. Good afternoon, everyone. Certainly, thank you to Malia for this opportunity and the rest of the Decent Center folks to just enter the conversation that you guys have been having for so long, and that we are just starting kind of as a field of study in Arkansas. So I'm going to just jump in because there's a lot of ground to cover, and if there are things that, I'm fine with you either, asking quick questions or waiting to the end. I guess, Malia, whatever way you want to do it. But my students interrupt me all the time, so I'll be fine.
I'll tell you what, if I see something that I think is like time sensitive, if people put it in the chat, I will jump in and interrupt, and otherwise we'll hold till the end.
That sounds perfect. All right, so what I'd like to do today is tell you a little bit about our project, Court Observation Arkansas, which we call COAR, and then talk about two studies that we completed and our findings as they relate to public defenders and court interpreters. And then I'm going to hand it to my colleague, Eliza Buckner. She's going to talk about a conceptual framework that we're kicking around to think about court practices and court reform. Hopefully we'll have lots of time for discussion. And our colleague, Diana Caravello, is on. She's our research director, so she can help us dig into the empirical questions if you have them. So COAR has a dual mission. So we were formed to generate original statewide empirical data on courts and how they function. But second, since we're based at a law school, we have that educational mission. We take on research projects that we know can help develop equity-informed legal leaders. And so this project really used court observation as a methodology. Many of you are very familiar with court observation, but it captures the real-time kind of public-facing experience of courtroom proceedings. On our project, we were able to contextualize those observations with interviews of 25 district judges. So this paper and presentation is going to focus on our public defender and interpreter findings, but you should know that we have many reports coming out. For example, we're working on now about ability to pay determinations. We have some pedagogical papers about our curriculum model. So there's lots of stuff coming out. We can talk a little bit about that in the Q&A if you'd like. But first, let's talk a little bit about Arkansas, which, like many states, operates within a landscape of structural challenges, right? And so Arkansas has the 7th highest poverty rate in the nation and the 3rd highest incarceration rate. There are significant racial disparities. Black Arkansans are about 15% of the population, but over 40% of the incarcerated population. We've had rapid growth in our limited English proficiency population, more than 300% since 1990. Yet the Arkansas Advisory Committee to the U.S. Commission on Civil Rights issued a report in 2024. We're going to reference that report a couple times today, that only 12 certified court interpreters were serving the entire state's 28 judicial districts. We have a very large veteran population, which adds another dimension, and we are considered a rural state. And so that spreads already thin resources or already sparse resources pretty thin. And so the advisory committee concluded in 2024 that all of this comes together to really magnify the heavy reliance on public defenders, court interpreters, and other court services. So this is a map of legal deserts. Many of you are familiar with the study that the APA released in 2020, and Arkansas is one of the most pronounced legal deserts in the country. We only have about 2.1 lawyers per 1,000 residents, which is far below the national average. And one dot represents, a lawyer, I think, for every 10 lawyers. And you see that there are some counties with no dots at all. So some of our most rural counties are operating without lawyers. All right, and so our district courts are, like many lower courts around the country, under-resourced, extremely important, but also understudied. So when we were putting together these studies, we went through a year-long development and feasibility phase, and our stakeholders consistently identified district courts as something that needed a closer look. So I know this graphic is a little fuzzy, and again, our district courts mirror the lower court system of many states nationwide, but we had an amendment to the Arkansas Constitution in 2001 that did formally unify our district court system. However, our district courts still rely heavily on local funding, staffing, and have varied practices. And so there's limited uniform oversight. In terms of jurisdiction, traffic matters, misdemeanors, probable cause determinations, and first appearances in felony cases will go through our district courts. And so in 2023, the Arkansas Legislative Audit was trying to get a sense of caseloads, financing, and counsel needs, and consistently noted the lack of resources and the huge caseload in district courts. And so many courts lacked audio recording equipment. Most proceedings generate no transcript. That's changed a little bit recently, but still the vast majority of proceedings, there's no record. And there is incomplete and underreported case reporting. So 2/3 of district courts do not report case level data. And some courts only report monthly totals. So that means that we don't even know how many public defenders we need, right? Because we're not even sure how many cases can be out there. And so when we sent our observers out around the state, some found different district courts that were quiet and formal and well organized and easy to navigate. But more often, this is what they found. Atmospheres that they were affronted with that were chaotic, busy, noisy, equipment that didn't work, the judge and attorneys talking over one another. Now, I don't think this is a surprise to most people on the call, but you can just think if a law student who has some level of legal training is experiencing the courts in this way, what vulnerable defendants are having to go through, right? So a little bit about our studies. I'm not going to go too deep into the methodology, but our study was from August 2022 to December 2023. We used a stratified sample based on 2021 caseload data, and we looked by county. So we had 14 counties that came up in the strata, 4 strata. Pulaski County, that's where Little Rock is by far the largest county, so it was its own strata. And you see that the counties spanned the state, very diverse geographically and in terms of rurality, but also diverse demographically, racially, economically, right? And so we really were able to capture the conditions around the state. And then we did an interview project with 25 judges, and some of them were in our sample, but we were also able to capture judges that were both outside our sample and outside those counties. We had 2 survey instruments that observers, after sitting through the court proceeding, had to fill out. We had a session level survey that looked at the high level kind of environment of the court, things like logistics, access, courtroom actors, professionalism, things that go into that traditional conception of procedural fairness. And then we had a case level survey that documented specific information about each proceeding. So things like charges and representation and language access and outcomes. And so we were trying to capture not only the overall perception of what happens in court, but how these court processes are experienced by participants. Now, I should say, an obvious point about court observation, but I can't underscore it enough that court observation provides a structured, real-time view of the proceedings, but it is limited, right? It is that fly on the wall perspective and limited to what observers can see and hear. They only had access to the docket some of the time. So they were trying to make judgments about what was going on, and we put them through training about Arkansas criminal procedure. But we have to kind of look at the data in that vein or through that lens. So in total, we were able to observe 330 sessions over this study period. We did move around the session observations to put a lot during the summer because that's when law students were available. They're trying to get back and forth to court around their classes. And after cleaning up the data, we had 282 sessions and over 10,000 cases. So this is a chart of the cases by strata, but even within here, we had a lot of variation. So if you look at that medium volume category, Craighead County versus Jefferson County, you notice that we observed 22 sessions in both of those counties, but it was almost 2 or 3 times the amount of cases that were in Craighead. All right, so on court observation and all of the neat research that goes on, we were really able to build on court watching models from around the country. So this is a little bit about how our study compared. So it was longer than most studies. The next one, I think, was Florida. And some court observation is very much ongoing. It doesn't have a study period. So this is just of the studies that kind of were limited in time. We were able to do a stratified sample. We're able to add in interviews. And it was important to us that we pay our law students and that we put them through that training and that oversight in getting the data. A little bit about how we differ a little bit. All right, so digging into some of our findings, I just want to say that for the most part, we align with what we know about the shortage of public defenders and court interpreters nationwide, but we're able to add that Arkansas slant and try to give some insight into how defendants are experiencing this. So in addition to that advisory committee report that came out in 2024, we had a pretty prominent litigation. I'm sure many of you have heard of it, the Farella versus Anglin litigation that was recently argued before the Eighth Circuit. And Farella held that a bail determination during an initial appearance proceeding, so that in Arkansas would be in district court, constitutes a critical stage of the proceedings and thus requires the appointment of counsel under the Sixth Amendment. Now, we had a symposium on these findings in November, and Greg Parrish, who is the executive director of our Public Defender Commission, he was actually a named defendant in the Farella litigation. He thinks that this is going to go on for a while, thinks that the decision is going to be appealed regardless of the outcome. So while other jurisdictions in reaction to Farella in the Eighth Circuit have started to amend their processes, Arkansas has not. So only in Judge Anglin's court are there now consistent counsel at first appearance hearings. The all around Arkansas, the state has chosen not to follow Farella. All right, so what did we see about prevalence? 74.1% of defendants in misdemeanor cases were observed without counsel. So this combines the custodial and non-custodial numbers. And this isn't just about their absence. This also talks about function, right? Because even when defenders exist, they're often not present at these critical early stages. So a summary a little bit about, kind of what we knew already, but what our data was able to layer on, certainly the prevalence, but the judges over and over again were expressing concern about the shortage of public defenders. And we saw this especially from our rural court judges. They were explicit in discussing the structural complaint, right? Not just talking about individual cases. One judge you see here is noting the lack of funding parity between the public defender and prosecutor's office. Observers over and over and over again described what they saw as a complete lack of assistance for defendants that appeared to need counsel. And we were able to document or to observe some of the creative solutions like public defender days that we hope that can be shared among the judges. So we really try to just report on everything. We're trying to share the good practices as well. So a couple themes here that we know what happens when there aren't public defenders, and we definitely saw that here. So it shows up most clearly in bail decisions, and particularly in the delay that lack of counsel causes. And again, judges were explicit about the structural nature of this problem. One judge you see is saying, I've tried over and over again for my probable cause in 8.1 hearings. I've asked, I've requested, I've begged, I've prayed. They say we're too busy, we're understaffed. Another judge describing that they would love to appoint counsel. They would love to say, go ahead and talk to your counsel, but instead they have to send them back to jail and wait for another time when counsel is present. We dig into the power imbalances. Now, it was notable that most of the judges expressed no concerns about the negotiated plea deals. They kind of deferred a lot to the prosecutors. However, our observers noted this power imbalance. And you see one observer here talking about how the defendant is forced to rely on the gratitude of the prosecutor. So this is showing that what should be an adversarial process is more administrative, right? More prosecutor driven. We're also able to just capture the reality, the conditions of representation. So observers repeatedly saw first-time conversation in hallways, in public galleries. This contributed often to what they described as the chaos of the courtroom. And you see this observer talking about prosecutors openly negotiating with unrepresented defendants. So lack of consultation space for public defenders, and then kind of very public discussions with the prosecutor. So we also looked at court interpreters and saw a significant gap between what was available and what the need was. And so in cases when the defendant explicitly asked for an interpreter, nearly 15% didn't receive one. Now that's a troubling number to me, but it's even more troubling when you think of the fact that this is only when the defendant knows their rights and knows to explicitly ask for an interpreter. So for defendants that didn't know to ask, or who tried to kind of go forward with their limited English proficiency, that's not captured in this number. All right, so we knew going in that Arkansas was operating with about 12 certified interpreters for the entire state. We were able to see how concerned judges were about this, again, particularly in rural counties. Observers noted a range of responses when defendants needed language assistance. Some responded in a very supportive manner, understanding that the need was there, making efforts to secure an interpreter, where others reacted with skepticism, even hostility, that the defendant would need services, right? Almost as if they were trying to get out of the proceeding. We commonly saw reliance on non-certified interpreters, right? So that could be family members, staff members, but not certified interpreters. So this quote is from an observer who is bilingual. And the quote was actually really long. This is an excerpt, who got very upset because they came to understand that the interpretation that was being given by the friend did not match what was going on in court. And the observer concluded this defendant didn't receive the same understanding of his case as other defendants. Even when judges were trying to be protective and delay proceedings in order to secure interpreters, the defendant bore that burden, right? The burden of coming to court, of getting to court, maybe of taking off work, and could not have their case heard. But what we often saw is that the communication of what was happening, if the interpreter wasn't there for the proceeding, the interpreter was not there to explain what was happening. And so this observer saying, I don't think they understood that they needed to return. So those are just some of our findings. We can dig in more. I'm going to kick it to Eliza to talk about the framework we're developing to think through this.
Thank you, Anastasia, and thank you to Malia and the rest of the Decent Center team for putting this together and giving us the opportunity to speak with y'all. So, before we kick off the discussion portion of this talk, we wanted to share some things that we learned about studying lower in particular, what it might mean to rethink justice from the bottom up. And that begins with a simple premise that the only version of the legal system most people know is the one they experience. And for most people, that occurs in lower courts, where experiences are shaped not only by the controlling statutes and case law, but also the variant procedures, unannounced customs, and disparate resources of the respective jurisdiction they find themselves in. And while it would make all of our jobs easier if finding the right policy or winning the right holding guaranteed faithful and total implementation across the board, we know things aren't so simple. But what if the apparent problem of lower courts, the gap between the law on paper and the law in practice, could tell us something more fundamental, not only about the legal system as a whole, but also how to change it? What if we thought about justice from the bottom up, seeing local courts as expressive of the way that justice is built and delivered on the ground? And what strategies might emerge alongside calls for impact litigation and policy reform? So, to that aim, we devised the conceptual framework of justice infrastructure to help pinpoint where both problems and solutions lie as justice travels from law on paper to law in practice. So, this framework is composed of three parts. The first is formal infrastructure, or the official rules handed down to lower courts. This tier represents how the law ought to work according to things like statutes and case law. In the context of public defenders, that would mean things like Gideon versus Wainwright, or even Farella versus Anglin, which is the case Anastasia was discussing a moment ago. The second tier is operational infrastructure, or the way in which courts attempt to implement formal rules, including faithful and memorialized procedures and innovations that are accessible and visible to the public. Here, for example, we'd include things like courts using scheduled public defender days to manage strain and resource scarcity. And the third is shadow infrastructure, which is when courts rely on informal and invisible procedures, which might be routine for a judge, but are not necessarily disclosed to the public. So this could be a judge determining a defendant's ability to pay based on whether they had an iPhone, or to use a lighter example, judges allowing a teen in traffic court to write essays to resolve their charges, both of which are things that we observed in our data. Importantly, our point is not that any of these tiers is intrinsically good or bad. The question, for example, of whether public defender days ultimately provide meaningful access to counsel is up for debate. But the value that we think this framework adds is that it provides shared language to describe variance and helps us think about the different scales of change that can coexist along things like impact litigation and statutory reform. So that might look like things including tailored judicial education. It could include things like county level campaigns targeted at changing discretionary spending. It might look like judges turning shadow infrastructure into operational infrastructure by formalizing diversion practices like the essay writing example I mentioned, and more. Ultimately, the point is that there doesn't have to be a single answer, but our hope is that members of the legal community not only continue fighting for needed system level changes, but also recognize that much can be accomplished even in the face of legislative deadlocks, split circuits, and an unpredictable Supreme Court if we ask not only how the law ought to be, but also how we can think about building justice from the bottom up. And so with that, I think we can open up to a conversation.
Excellent. Thank you. Um, Andy, I know you had a question.
Yes, hi folks. Thank you so much for this. This work is it's really outstanding, and it's very salient to us because we share your focus and concern, particularly with the lack of access to counsel in criminal courts at the earliest stages, and of course to other necessary services like interpreters, misstatement. I was wondering about your choice to do court observation. I didn't actually initially realize that this was a multi-state project also. I was wondering what were the lessons that you learned from doing it as a strategy? Is this something you would recommend to other people? And if you were to recommend it, are there any lessons learned that you would like to pass on about the strategy and how practical it was, what the pros and cons of it were?
Yeah, actually, if you could go, I don't know whether this is where you're trying to get. Yes, if we can hold there for a minute, I wanted to talk about this. So yeah, if we can hold there and you can answer Andy's question, and then
So I
I
will clarify, no, we focused on Arkansas. I was just providing here. My point is that while our data was unique, this methodology is not. And I hope that it can be leveraged around the country. And so there are 205 ABA accredited law schools. They're all by courts, right? And most law students don't go into court during law school. And we just saw during, when we mapped our what students were able to get out of this experience, that this was critical to their education, to their professional identity. So I think in terms of the implications for the methodology being situated at a law school, there are a lot of things that law schools can offer. And then we would be able to collect and share data from places where we wouldn't normally get it. So that is my dream, to kind of put an ongoing court observation project at all or most law schools and be able to collect data more regularly to coordinate on the type of data that we're looking at. In terms of lessons learned, the statewide model was really, really ambitious. It took so much time and coordination. So I think going forward, what we will do is try to chunk off either, sections of this sample, like go geographically, or we will look at more focused legal questions because our survey instrument just covered so much. So that's, kind of one lesson learned in terms of scope. Also, the value of our data was really in the reflections of our students and the judges. And so because the court observation data can quantify things, but it's not as reliable as if you had access to that docket information. And so we would really create more space for those reflections in the observers, because I think that's really where we got the context that was useful.
Yeah. Building on that, I mean, first of all, I want to make an observation because this went past and you're not going to kind of toot your own horn, but the sheer scale of this study is incredible. And you can see that just in terms of cases observed compared to the other two. I was at an ACDL when we did the Florida study. I helped put that together. So and then did two in when I was at the ABA, and the sheer scope of this has always been massively impressive to me. I wanted to talk about the decision to pair court observation with the judicial interviews, and whether that was sort of always the plan going in, why you chose judicial interviews as opposed to kind of interviews with other court actors, and what you thought that pairing brought you.
That's a great question. No, we did not go into it thinking that we were going to add the interviews. We were very open with the judges, even though these were public proceedings. We wanted to partner with stakeholders, so we sent out all the letters. We said our observers will be there. They'll have red clipboards. They'll have a lanyard. We had our feasibility observations over the course of a year. So we really built a lot of support for the project. And over again, the judges were saying, but the law students don't know what's going on. They don't know my decision making. They don't have all the information. And so we invited, that's where it came from. It came from the judges wanting to provide their perspective. We initially thought that the interviews would be an hour to an hour and a half. Some of them went on for 4 hours. We had to reschedule. They were in chunks. So they had a lot of opinions. Future research, to your point, Malia, we absolutely want to incorporate interviews from different demographics going forward. I think it's essential, and honestly, Arkansas just hasn't been studied in this way. So I think stakeholders feel like, wow, somebody is finally kind of listening, right, and interested.
Awesome.
So
Paige?
yeah.
Oh, sorry, Lindsay. Sorry, Lindsay, then Paige.
Okay. I was curious to know if you guys had any like consideration into like theories to guide like some of these questions, or the questions that I guess came up along the way, or frameworks that help guide yeah, some of your research questions and outcomes.
So I am going to kick that to
So
Eliza, because Eliza and I are digging into this. I want to make the point that Eliza comes to us from a deep academic background, but not the law. She is going to law school. We have gotten our hooks in her. So we've really benefited by her, kind of philosophical thinking on this. So you want to talk a little bit about that, Eliza?
sure, yeah. So I think it might be helpful to compare the types of frameworks we were employing at the outset and how the process of data collection might have changed the way that we go about interpreting our findings as we move forward. So I think in the beginning, we were very much committed to designing the study in a way that would allow us to think about questions pertaining to procedural justice. And so procedural justice as a theory that centers really on the question of legal legitimacy and how individuals who find themselves in a given courtroom will come to trust the legal decisions a judge makes independent of the substantive merits of their case. And so procedural justice focuses on equality of process and the enforcement of procedure for all defendants with the goal of increasing the legitimacy of the legal system. And while there are elements of that I think are absolutely crucial, um, I think one of the frameworks that we might be leaning on a little bit more heavily now is comes from Monica Bell and her work on legal estrangement. And legal estrangement suggests that uh, questions of substantive justice very strongly ought to be considered. And rather than doing away with procedural justice, she positions it as but one element of the degree to which not only individuals, but communities as a whole might be able to meaningfully access the legal system. And so she breaks it up into not just experiences of procedural injustice, but to that adds on structural exclusion and, very importantly, vicarious marginalization. And by vicarious marginalization, she's speaking to the way that an individual's adverse experience with the law, be that procedural or substantive, can spill over and inform an entire community's perspective, such that entire groups of people can become hesitant to turn to the law when they face challenges. It might make them less trusting, and it importantly shapes, their ability to meaningfully access systems that they should be able to access. And so her work on legal estrangement is really focused on and policing in particular, but we think it is really helpful for thinking through and prompting judges to consider how each time they are interacting with a defendant, that defendant might be bringing experiences from family members, from friends, from prior experiences, and that can inform their entire perception of the judicial system and the matter at hand. And so I can say more, but I think hopefully that covers at least maybe what the top line question is.
Yeah, Eliza, I'm going to suggest that you actually turn your camera off. You're breaking up a little periodically with your audio. So you may need to preserve bandwidth for that. Sorry. Paige.
Okay, sorry about that.
No, you're fine. We heard you. It wasn't that bad, but it happened a little during your presentation too. And I just am trying to your words are more important. So I'm going to preserve access to those. Paige.
Hey, I was wanting to ask, you mentioned about how some of the courtrooms you were observing were very noisy and chaotic, and the court watching stuff I've done in my local area that is very much the case. And so I was wondering if how did you overcome that difficulty, or if you had any advice for, how to navigate that, especially maybe for someone who doesn't necessarily have a ton of legal knowledge.
Yeah, that is a great question because we had the benefit of law students who had had at least 1 year of law school, but really knew very little about Arkansas criminal procedure because law school, we focus on federal law. And so we had to do a lot of heavy lifting with the criminal procedure component. So we developed an initial training module that's about 20 hours long. And it, some of that was just getting them on the institutional review board protocol, right? There's human subjects research training and stuff like that. But a lot of that is criminal procedure. We also added in stuff like, trauma-informed lawyering and self-care. And so that was one thing we did, is really trying to have that, that Arkansas criminal procedure. We would take students in for practice observations and pair them with experienced observers so that they could, talk to one another and learn what to look for. But I would say the component of training that we had really overlooked in the beginning that we added in was, the chaos of the courtroom can obstruct collection of data, but it can also just interrupt a person's ability to experience that environment because it is traumatic, right? It brings up, you're watching trauma, it may be bringing up and triggering trauma. And so we really underestimated the support that our law student observers were going to need. And that's why we added in that trauma training and are trying to improve that. So that's the advice that I would say, is that in addition to just the criminal procedure training, giving observers space for the emotional, and not expecting them to be robotic. And the more that they you can create a place of safety in observations, the better. I don't know if that's kind of what you're talking about. If that
Uh,
helps.
yeah, no. Or I was locally, we're thinking of trying to develop a training to get just encourage like ordinary people to go observe court proceedings to just get an idea of what the justice system is like actually like.
Yeah.
So we also, I will say that there are some organizations that you probably know of that are doing that. Court Watch PG County. We leaned heavily on Court Watch NOLA because they have the longest running court observation program. I think it's it's like 15, 20 years at this point. It operates differently than ours does because they're a nonprofit. We're an academic institution. But they had training that was useful to us. So we're happy to meet with you, by the way, and just share resources. And I know that they frequently consult with budding court observation programs.
Thank you.
I wanted to actually ask kind of a follow-up to that because part of kind of witnessing that chaos is actually the ability of the observer to not just understand what's going on, but be able to parse apart some of the legal distinctions that may be relevant. So, for example, if you're sitting in court watching, it may be impossible for an observer to understand whether someone in that moment is entitled to counsel. Because it may be that they're dealing with a citation and jail is not on the table. And because courts are very bad at announcing even the charges that are at issue, right? They read the case number and just assume everybody kind of knows what's happening because the only two people they really, care about are the people who are standing up, understanding what's happening in that moment. That that things like that really impact and can be limiting in terms of the role of court observation. So I was hoping you could go to your 74% number on the people, who kind of didn't have counsel and talk a little bit about what training you gave people, how that number kind of how you got to that number and what uncertainty might still be in there.
Yeah, that's a great question because we actually pulled back from some of the prevalence numbers and counting of things for that very reason. Because even in the numbers for misdemeanors, like I said, this is custodial and non-custodial defendants. We had broken it down a little bit between misdemeanor and felony, but sometimes we don't know. So you'll notice that in a lot of numbers we say observed, right? So we're not saying that this is the number, we're saying this is what we observed. We also don't know if they talked with somebody in the hallway, right? So we are just trying to capture in the defendants that came up when we could ascertain that it was a misdemeanor case. Was there a lawyer with them, right? So within those broad parameters, I have come to be confident. I have to confess, when I first saw this number, I was like, there's no way, there's no way that can be the case. There's no way, but it absolutely is, as I was digging into, what the judges were saying. And Malia, you and I have talked about how this number is pretty consistent with what others have found. But I think your larger question is, as to the counts that you can make through court observation, why I've said that one of our lessons was really shifting towards the more qualitative and impression-based data, right? Because there is a count, right, that is useful, but I think what is more useful is giving the public an idea of what's really happening on the ground. And you don't need to know, right, exactly everything about the case to know that the defendant seems confused, is having to negotiate with what looks like the prosecutor and what effect that's having. was a convoluted answer, but I think it grew into some of our lessons.
No, so could I actually ask you to say a little more there about some of the things you had been hoping to count that you had
Yep.
to kind of back off? Because I think those lessons learned, which often we can be afraid to admit to, are some of the most important lessons.
Yeah. So, for example, so we were really aggressive with this survey. I think it was the case level survey was 91 points. It took observers often as much time as they were in court in order to fill out the survey. And I'm sure Andy is, laughing a little bit right now, but I'm a lawyer. I don't have empirical training. And so I thought we could go in and simply make all types of inferential analysis, such as when the attorney was this race and the defendant was that race, and it was this type of proceeding, like we could make those counts, and we could make a causal analysis, right? Being in a rural court caused this. It caused a longer bail amounts. That is not what court observation can do, because you have that fly on the wall perspective. So we can count when the defendant is asking for an interpreter and they don't get one. That is a count that we can make. It's really, in like well in front, but we can't quantify how many people need an interpreter. We don't have a way of getting to that. We can look at population, right? We can map, we can look at the counties, but we don't know how many people actually needed one, right? We cannot make a causal analysis about release determinations because we don't have any of the case data. We don't know. We might know that it's an assault case, but we don't know about a defendant's criminal history. We don't know about the circumstances and all of the metrics that the court is using to set bail. But we know what the ability to pay statute says, and we can watch and see, are they asking those questions, right? And so I think it is very much trial and error, and that's why I would like to standardize, at least among law schools, the types of questions that we ask, because I think there are some very observable points that are useful. Malia, you talked about timing proceedings. And that, we did a little of that. We had observers estimate the length of proceeding. And that's a simple thing that's observable, right? And backs into research. So that's really, I think that you're not able to do a lot of that causal analysis with court observation data. And so really pairing what you're able to see with the interview data or with the observations, your observers are a huge source of information. They are the proxy for the public. So I think it does mean carefully crafting your research questions. And also we exhausted our observers a little bit.
Yeah, and I mean, look, there's an ongoing struggle, right? Because you want to standardize it, but the procedures are so different everywhere. The considerations are different everywhere, right? Even though they are often similar, right? And so like this piece about trying to standardize is complicated by just the intense diversity of process that exists.
So we know that public defenders, we know that the quality of representation in public defense can be poor, right? And so if we focused in on that, for example, and coordinated and shared data, we could simply ask observers whether they saw public discussions between public defenders and their clients, and what was their sense of those discussions.
Mhm.
And we could talk about the lack of public spaces. We could do something around that where you wouldn't have to have that procedural knowledge. And if they didn't see those interactions, then we could talk about that prevalence, right? So if we're specific about the research theme, then we might be able to find some places that can be observed around the country in a similar way. And most academic institutions have access to the types of software that would make data sharing easier, and sometimes the nonprofits do not. Right. And so if it's led by the academic institutions that can share those resources, I think there's promise there.
And the academic piece is an interesting kind of add, because correct me if I'm wrong, but your goal in doing this was to essentially, like, it was sort of academic, to put the findings out there, make them known, maybe draw some lines to some potential improvements, but really at most to kind of make some recommendations and observations, as opposed to some of the court watches like PG County that have been more activist in their orientation, right? I mean, for those who don't know, that is a court watch that files like judicial grievances if they feel like judges are not following the rules, or for example, not asking the right questions about ability to pay. And I think that in this kind of court watching world is a really interesting division in kind of approach that we have to kind of consider and think about whenever you're thinking about what are you going into this for. And it Lauren's piece about trying to bring together people that are doing court observation, I think that kind of goal piece is a really interesting dynamic in these different court observation groups and who's doing them.
Yeah, one of our appendices to this report does survey the court observation programs and their structure, a little bit about their structure and their purpose. And I think there's room for all of it. I think it's such a useful methodology, and it can engage the public, it can help students. And so I think it should be as broad as possible and from as many organizations as possible. At an academic institution, you are limited by the Institutional Review Board. You are limited in how you can report the data. You are, there in the confidentiality of the data. And so that is a consideration as well. What we've tried to do is have relationships with the community such that they're positioned to use the data. And so even though we're making recommendations and we may not be the one that's drafting legislation, that those who are interested in drafting that legislation are empowered to do so.
Amazing. Thank you. Anyone else have questions? This is a small enough group that if you do, please feel free to just unmute.
Yeah, I'm going through the chat, all the great information.
I know. I feel I have never felt so like we've done our job. The whole point is to bring researchers together to communicate across things. And look at that. It's just happening. Nate.
On the training point, I noticed a couple of people are asking about that. I will say that next month we are, I convened a roundtable at the Law and Society conference. Malia, I don't know if you've ever gone to Law and Society, but it will be all about our training module and our curriculum module. And so I will be collecting lots of ideas about what needs to go, what we've done, what needs to go in there. And we also want to make it interdisciplinary. So it's not just lawyers, it's, public health, professor thinking about how court observation can inform public health education. It's a couple professors from our criminal justice department. Yes, Lauren, yes. Come to our stuff and we will come to yours. We'll connect. So that is to say that I think in the next month or so, my ideas about training will be more developed.
Sorry, Nate. Now you get to go.
I was just wondering, I think I remember seeing that y'all had involved like 54 paid law students or something like that. And I was thinking about that in the context of the 20 hours plus of training required. And I'd be interested in hearing your thoughts on sort of whether whether the goal was to have like a broad number of students for a reason, like because you wanted to send a bunch of people all out at the same time, or because you were trying to like build a movement of folks who could keep doing this, or like whether if you were doing it again, you would be happier with a smaller number of students that like if they got better over time doing that. I'd just be interested in like hearing your thoughts about whether the number of how you arrived at the number of students you had.
That's an excellent question. So we had a grant, $1 million grant for this project that envisioned a broad base, like that was really focused on professional development and envisioned a large group of students. And we advocated for them to be paid students, and we wanted to pay them at near of a level as they would get, from law's firm clerking, which in Arkansas is pretty low. So they were paid $17 and $20 an hour. And so there was that mission, Nate, very broadly to try to reach as many students as we could. We have now developed a co-curricular program where students can earn academic credit by working with us. And that is the model that I think is viable going forward. Right, because we can, all law schools can have co-curricular credit. I forget what the ABA limit is, but it allows students to have 1 to 2 hours. And if you have a focused research question, you could work with a small group of students, give them a really deep experience. The nice thing about having that many students is we were able to understand what were the most salient points of development for them. And so now we're trying to build that in. But no, I do not want to supervise 54 law students over 16 months ever again. And we had a phenomenal full-time program manager who we just could not have done this without, because I am on the full-time faculty.
Great, thank you.
Lauren?
Hi, sorry, I'm kind of running around, so I'm not on camera, but thank you. This has been a really great presentation. So thanks to the Decent Center for organizing it. It's been really fascinating to hear about the study. I don't have a question per se, but since I sort of interjected this into the chat, I guess I just wanted to explain a little. So I'm on the faculty at Vanderbilt Law School, but have done a lot of court observation as part of interdisciplinary research before this, and even at the Southern Center when I was a lawyer. So a couple things. One is I don't know how many other folks on here are in law school or other educational settings, but we teach a Court Watching 101 class where it's not for research purposes, although we have students do some data collection, but it's mostly for educational purposes, and we have students observe criminal court, landlord-tenant court, and family court. And part of the idea is to sort of also compare their experiences across courts. But like the presenters were saying, I think it's been we created this course in part because a few of us were having students observe court as part of our regular classes, and then found that it would be helpful to actually offer them some credit and focus on that exclusively. So if people are interested, I'm happy to share that syllabus or how we do that, or the data collection sheet. But I have been in conversations with some folks at Pew for about a year. It started with the idea of maybe creating a standardized observation sheet so that even though obviously people are observing different courts, there might be certain things common across courts that might be interesting to collect as a more standardized matter. So that was part of where the idea for this convening started. And we actually did reach out to someone at Arkansas. I think it was Zoya Miller. It looks like she's at legal aid, not at the law school. So, but I'm not sure if she's coming and so apologies if I'd known about you all. Now that I see everyone on this thread, I'm like, oh, we could have invited even more people, but I know
Yeah,
that
Zoe is no longer with us, but she was the program manager. So I would
Oh,
love
okay.
information about the convening. She may have just overlooked it.
But in any
But
event, I'm happy I took everyone's email, and I don't know what will
yeah,
come out of this.
absolutely.
It's in basically a week, so at this point it's pretty soon. But I know that Court Watch PG County and Court Watch NOLA are coming, as well as there's some academics, but it's not purely academics, it's also other organizations. But I think part of the idea was just it doesn't, even though there were these limited efforts of people doing this, it felt like there wasn't this. Obviously, this webinar is a great start, but there wasn't really this opportunity for folks to connect on this specifically. And obviously, everyone has a different angle, right? Some are more interested in research, some are more interested in community organizing or impact. But hopefully, this will just be the beginning of a larger conversation. And hopefully, I'll be able to join your roundtable, or not the roundtable, but join your session at LSA as well. So thank you.
Absolutely. I would love that. And if our times conflict, then let's just try to set aside some time. Because I know you guys have that curriculum. Toro has a similar curriculum, both that are focused on the curriculum model, but I just think that there's a lot that we can learn from one another and make it a movement.
How did you all obtain funding? Funding for all of this? It feels like criminal justice funding has been like very hard to come by lately.
So this was the grant came out. It was a corporate grant from Walmart in the wake of the George Floyd summer, when all the corporations were making deep racial equity commitments. And so that we were at their now defunct Center for Racial Equity. And so part of what we tried to do in addition to developing all this data is to figure out ways for schools to do this in a sustainable way with a lot less funding, which is something that I'm still thinking through, but that's where the grant from. So we are actually just now working on dissemination. We do not have any active observations going on.
Okay, so noting that we have 5 minutes left, I'll let Dr. Davies get the last question in because his hand is up.
Oh, thank you. This is really a small one, but I do want to ask it just because I see our friends from TIDC are here as well, and they also publish data about the rate at which people go without representation by counsel. But the way they count it is they count anybody who receives representation at any point in the case as having had counsel. And as I appreciate it, your 74% rate was based on going into court, seeing a person that day, and whether or not they had counsel that day. And as I appreciate it, you won't have been able to follow that person through their case and find out if previously or later they had it. So I wondered if within your 10,000 court observations, you were able to break down the stage of the case that it was at. And for example, Malia already alluded to the possibility that perhaps the person was entitled to counsel, but are you able to distinguish people who were in court for the first time versus people who pled guilty that day and whether they had counsel?
We tried to characterize the type of proceeding. As we went along, we became less confident in that data, given that sometimes we had the docket and sometimes we didn't. It's very hard to distinguish, for example, between, sometimes the appearance is the first appearance and the sentencing, the plea and the sentencing. Sometimes it's a status, right, where they're coming back and saying we can't pay. And so we weren't really able to reliably make those distinctions, especially when we did not have a docket. And so we started just making kind of the basic observation. I do think that the 74% number is important because a member of the public who is sitting in court and trying to figure out their case and their rights that is their experience. There is no lawyer in the room. Right. And so that sets the culture, which is why I think we were so I was very committed to kind of reporting out what the observation was there, regardless of, I mean, sometimes we knew because we're listening to the misdemeanor docket. We're not over on the traffic docket. So in those slices, we could make distinctions. But yeah, it's very hard to make a distinction between the trial and the plea and the status hearing, right? All of the different types of proceedings. It would be easier to determine once you're at a more trial level court and not that county court.
Thank you.
Sorry. Well, I want to thank everyone for being here. I want to just, as a final point, kind of ask about next steps in Arkansas, because we heard a little bit of the context. But sort of what are your next step goals for kind of pursuing the reform elements, if you have any? I will say I'm gonna ask one of my colleagues to drop in the paper, kind of the our policy paper, kind of to give people more background on what is going on in Arkansas and some of the efforts to pursue reform. But I would love to land on what your goal is for kind of improving the system coming off of this observation project, because I know that even though you were at an academic institution, you're very worried about the real world consequences. So want to have that as our last question, and then we will disband and thank people for their time.
Thank you. So the caveat that I will make, that is not true at all academic institutions, is that I am at a public institution in Arkansas. And so the limits on my pursuit of reforms is very real and explicit. That is not what all those are not the parameters that all academic institutions operate from, which is also why I think it's promising if we could, spread this out. So in the near term, our goal is just dissemination of all of our findings. We have a set of educational materials. We are just meeting with everybody who will listen. And what we're hearing is that those stakeholders are interested in pursuing reforms. We want to take that infrastructure, which I know isn't, just the idea of talking to judges about all of those shadow practices and helping make them more operationalized and have a more public function. So I think that is our reform, right? Getting a place of creating language where we can conceive of practices and reforms. I want to make it sustainable. So of course, getting more projects going. We are deeply interested in the criminal justice system as a whole in Arkansas, but I think if I had to pick a couple of topics, it would be public defenders, court interpreters, and ability to pay determinations. So, release determinations, fines, fees. That was really where we started, and those are kind of the two big substantive chunks. And so I would expect that our future research is going to continue to drill down in those areas and support reform efforts.
Amazing. Well, thank everyone for being here. The one thing I will say is that we are always looking for great kind of up and coming work to feature. So if you have research in progress, or of someone with interesting criminal justice research in progress, please reach out and let us know. And we will gladly host one of these with a different focus. And thank you all for being here today. And thank you, Professor Bowles, for this amazing project, and just exceptional volume of work.
Well, thank you. And thank you so much for your feedback and your questions, and hopefully the start of many conversations.